Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Ripple versus CC appeals threat to delay settlement. There's been a hectic week of discussions and anticipation around the Ripple vs XEC case, bringing it closer to the possibility of a resolution. On the other hand, XRP advocate Bill Morgan says that the SEC might extend the process by filing appeals and injunctions, which has sparked discussion about the influence that this will have on the future of XRP. First, let's look at what the future holds for XRP in the remaining days. Impasses in the way of resolution as a result of the efforts made by the Securities and Exchange Commission to get an injunction to halt Ripple's on-demand liquidity, oat sales, and its intention to appeal programmatic sales. Bill Morgan notes the significant barriers that stand in the way of achieving a settlement. Both parties may face difficulties as a result of these activities, which point to a protracted legal fight being involved. Greater challenges to resolving include the Securities and Exchange Commission's intention to appeal programmatic sales and its pursuit of an injunction that would prevent OD sales. The effects of such delays may have repercussions throughout Ripple's operations as well as the larger XRP market, depending on whether or not the SEC is successful in putting a stop to them. Ripple's business, notably its ODL sales, could see disruptions. The price of XRP, which is now hovering around 50 cents, might also be affected by disruptions of this nature. XRP advocates, on the other hand, predict a jump in value if a settlement is reached, with Morgan aiming for a post-settlement valuation of $1. There has been a decline of 4.48 in the value of XRP, which is settled at 5,011 cents. Within 24 hours, the volume of its trading has increased by 33.42%, reaching $795.94 million, 94 cents million. Despite this, its value has decreased by almost 7% over the past week, leading to a monthly decline of approximately 20%. This exemplifies the current volatility and downward trend in the price of XRP. What comes next? Within the realm of the law, Judge Sarah Netburn has granted the Securities and Exchange Commission until April 29, 2024 to react to Ripple's opposition to the proposed civil penalties that the agency has recommended. Furthermore, the Securities and Exchange Commission, CIC, getting ready to submit its opposition brief to Ripple's motion to strike by the 29th of April, and its reply to contest Ripple's opposition brief is due by the 6th of May. The Securities and Exchange Commission is seeking a substantial penalty of $2 and billion an injunction against Ripple, and these documents hold the keys to the case's conclusion. Despite this, it is highly improbable that the verdict will change the commission's decision to appeal the finding on programmatic sales of XRP, controversies, rebuttals, and complete anarchy. Ripple, on the other hand, is arguing that the SEC's charges are overblown, that there is a lack of solid evidence to support them. They are calling for a penalty that is capped at $10 million. In the ongoing dispute between Ripple and the SEC, the comments from both parties will be of critical importance in establishing whether or not a settlement is within reach. In the context of the broader cryptocurrency ecosystem, additional cases such as XEV, Coinbase and Consensus vs. SEC have the potential to influence the techniques employed by the SEC, according to the insights provided by Bill Morgan. More specifically, Consensus has challenged the classification of Ethereum as a security by filing a lawsuit against the Securities and Exchange Commission SEC. A decision that is favorable for Consensus has the potential to influence the strategy that the Securities and Exchange Commission takes to regulating cryptocurrencies, as well as its appeal against the decision regarding programmatic sales of XRP. Concerns have been raised concerning the regulatory status of ETH, or sales of ETH, which has caused the cryptocurrency community to feel apprehensive. Consensus is currently in the firing line because its creators remain anonymous and the Securities and Exchange Commission is unable to identify any of them. Bitcoin continues to enjoy an unending market advantage. Ripple and the United States Securities and Exchange Commission have been engaged in a legal struggle for more than 3 years, and they have finally entered the trial phase of their confrontation. It is important to keep in mind that the action against the corporation was initiated in December 2020 when the watchdog accused the company of illegally raising more than $1.03 billion through an unregistered securities offer. In response to the allegations, Ripple said that its native token should not be categorized as an investment of this kind and was therefore exempt from the agency's authority to regulate such matters. Within the context of the trial, there are several developments and duties that both parties are required to fulfill. A fresh scheduling order was entered by Magistrate Judge Sarah Netburn a few days ago, and it mandated that the Securities and Exchange Commission submit its response to the petition for remedies and entry of final judgment. Ripple was given 3 business days to respond after the commission is expected to have completed the task today. But the commission has not yet started because Judge Netburn has a somewhat favorable posture toward XRP. Numerous industry insiders considered her participation as a positive omen for a decisive triumph for Ripple. While she was expressing her opinion 3 years ago, she stated that the native cryptocurrency of the company possesses a utility that distinguishes it from Bitcoin and Ether. Possible repercussions for XRP: throughout 2023, Ripple was able to obtain 3 partial court victories, and the price of XRP responded favorably to each of these victories. Multiple analysts have predicted that the business will see a significant bull run if it is successful throughout the trial. For those who are interested in learning more about the case and how it is related to the future price fluctuations of XRP, please watch the video that we have dedicated to this topic below. The legal dispute between Ripple and the United States Securities and Exchange Commission, SEC, moved forward to the trial stage last week. And many people are anticipating a resolution to the dispute shortly. The motion for remedies and the final judgment were the subjects of the revised schedule that was announced by attorney James K. Phelan. The schedule was created by Magistrate Judge Sarah Netburn. Response from the SEC is required by the 29th of April, and Ripple has 3 business days to react after that date. An important week for Ripple, and the SEC Magistrate Judge Sarah Netburn has established a timeline for the ongoing case between Ripple Labs and the Securities and Exchange Commission, SEC. This week is a crucial one for both cryptocurrencies. This timeline is related to Ripple's attempt to disregard the most recent expert testimony presented by the SEC, which is designed to support the company's position for sanctions and a decisive ruling. In response to Ripple's application, Judge Netburn has granted the Securities and Exchange Commission an extension until April 29, 2020 to submit their counterarguments. When that time comes, Ripple will have 3 business days to respond. In light of Judge Netburn's recent nomination to the position of district judge in the Southern District of New York, this amendment to the schedule has been implemented. She continues to serve as the presiding judge in the Ripple Varves SEC case, where she is frequently praised for her fair decisions, which are widely regarded favorably by the cryptocurrency community. Despite her new post, she continues to hold this position. My understanding about XRP is that not only does it have a currency value, but it also has a utility, and that utility differentiates it from Bitcoin and Ether. The judge remarked in 2021, according to counsel Jeremy Hogan, this statement was made about blockchain technology